Hello friends, welcome back to series of lecture. This is the 53rd lecture of this series of Indian Evidence Act, and in this lecture we would start with section 42. So it is written, judgments, orders or decrees other than those mentioned in section 41 are relevant if they relate to matters of a public nature relevant to the inquiry. But such judgments, orders or decrees are not conclusive proof of that which they state. Judgments, orders or decrees other than those mentioned in section 41 are relevant if they relate to matters of a public nature relevant to the inquiry, but such judgments, orders or decrees are not conclusive proof of that which they state. A conclusive proof सिर्फ section 41 में मिलेगा. Such judgments, orders or decrees are not conclusive proof of that which they state. So conclusive proof सिर्फ section 41 में मिलेगा. अगर judgment in rem है तो section 41 में if it is passed by either of these four courts it will be conclusive. Otherwise, if it is not a judgment in rem but it is of a public nature, it is no doubt that it is relevant, but it will not be a conclusive proof. For example, A sues B for trespass on his land. B alleges the existence of a public right of way over the land, which A denies. अब यहाँ पर what right this B claiming? He is not claiming any individual right. He is not claiming individual right. He is claiming that it is a public way, and therefore I also have the right to pass through the land. A says that it is a private land, and B says that it is a public right, and therefore being it is a part of the public, he is a part of the public, he is also having the right to use that land, and the judgment is passed. अब आगे बढ़िए. The existence of a decree in favor of the defendant in a suit by A against C for a trespass on the same land in which C alleged the existence of the same right of way is relevant, but it is not conclusive proof that the right of way exists. What happened was, suppose this is a piece of land and there was a suit between A and B, and A is claiming that this is my land, private right, and B is claiming that it is a public way, and A is claiming that being a member of the public I have the right. Now the court decided in favor of B, and it declares that it is a public way. Now again tomorrow, if there is suit between A and C upon the same thing, that C is claiming that it is a public way and public right, and A is claiming that it is my property. Now in this suit between A and C, the issue is the same, whether that particular land is a public land or not. Will the previous judgment in which it was declared that it is a public land, will that be relevant in this suit? अब अगर ये private right होता, then it will not be relevant. But since here it is public right is involved, so it is relevant. So previous judgment can always be relevant in this case. But will the previous judgment will be a conclusive proof? Answer is no. अब देखो section 40. In section 40, any previous judgment which bars the trial, suit or proceeding, so that will be relevant. In section 41, any judgment in rem passed by the any four courts which is mentioned in it will be relevant, plus it will be conclusive proof also. But in section 42, if the judgment is about any public right, then subsequently if the suit is regarding the same public right, then the previous judgment will be relevant, but that will not be a conclusive proof. वो मतलब सिर्फ कोर्ट का एक टिल्ट ऑफ माइंड बनाएगा कि पहले भी ऐसा डिसाइड हुआ था और इसी जमीन को एक पब्लिक राइट डिक्लेयर किया गया था. So that will be a tilt of mind for the court, and that is a relevant fact, but that will not be binding upon the subsequent court. Subsequent court will take the evidences once again. It is only a relevant fact. Now see section 43. judgment orders or decrees other than those mentioned in section 40 till 42. The 40 is bar in the trial, or 41 is about the conclusive proof of judgment in rem, and 42 is public right. Now they are saying that in 3 के अलावा the previous judgment will not be relevant. So that is what they are saying here. Judgments, orders and degrees other than those mentioned in section 40, 41 and 42 are irrelevant unless the existence of such judgment, order or decree is a fact in issue or is relevant under some other provisions of this act. मतलब ये कह रहे हैं कि ये जो जजमेंट्स हैं 40 से 42 तक उसको छोड़कर कोई भी और प्रीवियस जजमेंट रेलिवेंट नहीं होगा unless they are relevant under some other provision of the Evidence Act. So it may be relevant under say some other provision, say previous conviction, section 14 याद करो, character evidence याद करो. Character evidence can be relevant as of character. Previous conviction can be relevant as of evidence of character or as an evidence of similar transaction earlier. So in that way there may be certain judgments which may be relevant. There may be certain judgment which create. There may be previous judgment which create motive. जब जैसा ए ने बी के खिलाफ केस किया था जमीन के लिए और ए केस हार गया. So the previous judgment says that the land belongs to B. Now A, because he lost in that suit, it creates a motive to kill B, and he actually go to kill B. He actually no doubts kill B. So is not the previous judgment relevant? So is not the previous judgment relevant to the extent of section 8? It constitute the motive. मैं केस हार गया और मैंने केस हारने की वजह से मर्डर कर दिया अपोजिट पार्टी का, तो ये जो प्रीवियस जजमेंट है उसी की वजह से मोटिव क्रिएट हुआ मेरा मारने का. सो दैट प्रीवियस जजमेंट कैन बी रेलिवेंट अंडर सेक्शन 8 टू कॉन्स्टिट्यूट द मोटिव. सो द प्रीवियस judgment is relevant under section 8 to constitute the motive. Similarly, the previous judgment can also be relevant in the previous conviction, for the previous conviction, for section 14, 53 या 54 that ways. तो देख लीजिएगा आप, I think it is 54, 14 and 54. अब illustration देखिएगा. Illustration है A and B separately sue C. A and B separately sue C for a libel which reflects upon each of them. अब मान लो C ने कुछ publication किया जिसमें A is also affected and B is also affected. So that is the defamatory done by C in which A is also affected and B is also affected. और अब हुआ क्या, A ने भी सूट कर दिया C पर, A ने भी सूट कर दिया C पर और B ने भी सूट कर दिया C पर. Both of them respectively file their suits against C. Now C in each case says that the matter alleged to be libelous, is true, and the circumstances are such that it is probably true in each case or in neither. What they are saying is कि C का कंटेंशन अब दोनों सूट में है कि जो मैंने पब्लिश किया था that was true. Means he is taking the defense of true publication, and they are saying that the circumstances are such that the publication may be true or it may be untrue for both. तो true है तो दोनों के लिए true होगा और untrue है तो दोनों के लिए untrue होगा. That is what they are saying. अब A obtains a decree against C for damages. अब A को पहले वाले सूट में he got the decree. Means what? C was unable to prove that it was a true publication. Now the fact is irrelevant as between B and C. A obtains a degree against C for damages on the ground that C failed to make out his justification. The fact is irrelevant as between B and C. अब क्वेश्चन है कि ये जो सूट है बी एंड सी के बीच, ये जो सूट है बिटवीन बी एंड सी, उसमें ये जो डिसीजन है ए और सी के बीच का फर्स्ट सूट का, would that will be relevant. Now it will be relevant only if it falls under section 40. So it does not fall under section 40. Defamation suit is not a judgment in rem and it is not a public right. So 40, 41 and 42 will not apply. Therefore 40, 41 and 42 will not apply, and this will be relevant in any other suit only if it falls in any other sections in the Evidence Act. And if you go through the other sections in the Evidence Act, and you will find that this will not fall in any of the section. Therefore this judgment is not relevant in the subsequent suit. अब आपको लग सकता है कि इसी बात पे ए और सी के बीच में सूट चल रहा है और कोर्ट उसके ऊपर डिसाइड कर चुकी है कि वो ट्रू पब्लिकेशन नहीं था और एक ही सिंगल पब्लिकेशन था, तो उसको उस जजमेंट को यहाँ पर रेलिवेंट होना चाहिए सेकंड सूट में, लेकिन ये रेलिवेंट नहीं होगा क्योंकि ये किसी और सेक्शन में रेलिवेंट है नहीं और 40 till 42 में ये रेलिवेंट है नहीं. सो देयरफॉर इट विल नॉट बी रेलिवेंट. सो this may confuse you in the exam, so please read the illustration very carefully and remember that in your mind that in these cases it may appear कि जब एक ही पब्लिकेशन था तो वो अगर ट्रू होगा तो दोनों के लिए होगा और फॉल्स होगा तो दोनों के लिए होगा. अब ए वर्सेस सी में ये प्रूव हो गया दैट पब्लिकेशन इज फॉल्स, मतलब दोनों के लिए फॉल्स प्रूव हो गया, तो फिर ये चीज़ सेकंड सूट में क्यों रेलिवेंट नहीं है? रेलिवेंट इसलिए नहीं होगा कि सेकंड सूट इज एन इंडिपेंडेंट सूट, सेपरेट सूट, एंड द मैटर इज नॉट रिलेटेड टू पब्लिक राइट, इट इज नॉट अ जजमेंट इन रेम एंड इट इज नॉट बार अपॉन द सब्सिक्वेंट सूट, इट वुड नॉट apply bar upon subsequent suit, and it will also not relevant in any of the other sections. Now see illustration B. A prosecutes B for adultery with C, his wife. A prosecute B for adultery with C, his wife. B denies that C is his wife. B कहता है कि ये तुम्हारी वाइफ है ही नहीं. Now you know that adultery falls, earlier it falls in criminal and civil both, but now adultery is no more an offense. So suppose this example for civil only. A sued B for adultery with C, A's wife. B denies that C is A's wife. B deny कर देता है कि C A की wife है ही नहीं. अब who is C? C, A and C are lawfully wedded. C is the wife of A and C is in with adultery of B. अब A files suit for adultery to B. A files suit upon B. और इसमें B क्या करता है? B denies that C is A's wife. C A की wife है ही नहीं. But the courts convicts B of adultery. So this B is convicted for adultery. जब convict criminal हो गया तो suppose B decide the civil case in favor of B in disfavor of B for adultery. Means what? अब इधर in disfavor of B कर दिया तो means court has accepted the fact that A and C are lawfully wedded. अब afterwards C is prosecuted for bigamy. अब हुआ क्या? बाद में C ने शादी कर ली मान लो B से. If C is already married to A, now C got married to B, so C is prosecuted for bigamy. Afterwards, C is prosecuted for bigamy in marrying B during A's lifetime. If C says that C never was A's wife. अब सोचो यही सवाल पहले उठा था, whether C is A's wife or not. This question was earlier decided, and the suit was in disfavor of B for adultery. Now in this case again this question arises that I am not A's wife. C is saying that I am not his wife. तो क्या इस केस में ये प्रीवियस जजमेंट रेलिवेंट होगा? अब इसको आप सोच लीजिए that it is not a public matter. अब adultery शादी से related जरूर है but it is not matrimonial proceeding. That will be earlier if it was a criminal then it is in the court of magistrate, and if it is not then it is in the civil court. Therefore matrimonial में fall नहीं करेगा. बार इन subsequent इस पे लगेगा नहीं. subsequent suit बार इन जो बार है आप upon the subsequent suit वो वाला इस पे लगेगा नहीं. पब्लिक राइट ये है नहीं. सो 40 से 42 तक कोई भी लग नहीं रहा. अब if it is relevant in some other section then it will be relevant here, but that is also not the case. It is not relevant in any other section, and therefore what they are saying is the judgment against B is irrelevant as against C, because it is not relevant in section 40 to 42 and it is not relevant in any other section also. Now whether it is relevant in any other section or not, उसके लिए आपको सारे सेक्शन एग्जामिन करने पड़ेंगे. तो उसके लिए आप सारे सेक्शन एग्जामिन कर सकते हो. किसी भी सेक्शन में अगर कहीं फॉल कर जाए then it may be relevant. Now next, A prosecutes B for stealing a cow from him. B is convicted. मतलब B ने गाय चोरी की थी और B कन्विक्ट हो गया. अब A afterwards sues C for the cow. अब उसने किसी थर्ड पर्सन के ऊपर सू किया. The cow which B had sold to him before his conviction. अब B ने गाय चोरी करके किसको बेच दिया? C को. A की गाय को B ने चोरी किया और उसने C को बेच दिया. अब A ने B पर प्रोसिक्यूशन किया and B is convicted. The fact that he has stolen the cow is proved. Now A files the suit against the C to recover back the cow. A afterwards sues C for the cow which B had sold to him before his conviction. As between A and C, the judgment against B is irrelevant. Again, the same logic will be there. Now you see illustration D. A has obtained a decree for the possession of land against B. C, B's son, murders A in consequence. अब A ने B के खिलाफ डिक्री ले लिया. For what? For the possession of land. A took the decree for the possession of land. Now B का जो son है, he got annoyed by that. The judgment against B gave rise to the formation of motive in the mind of B's son, and B's son kills A. अब is the previous judgment is relevant found? It is relevant because the judgment is relevant as showing motive for a crime. The existence of the judgment is relevant as showing motive for a crime because उसी judgment की वजह से उसने बदला लेने के लिए उसको मारा. So that judgment in favor of A gave rise to the formation of the motive in the mind of B's son, and therefore this judgment will be relevant to prove the motive. ये सेक्शन 40, 41 और 42 में रेलिवेंट नहीं होगा, लेकिन सेक्शन 8 में टू प्रूव मोटिव इट विल बी रेलिवेंट. is next illustration. A is charged with theft. A is charged with theft and with having been previously convicted of theft. The previous conviction is relevant as a fact in issue. अब previous conviction क्यों relevant होगा? Section 75 IPC, it will increase the sentence, क्योंकि सेंटेंस का क्वांटम भी तो फैक्ट इन इशू का पार्ट होता है. तो अब अगर आज आप चार्ज हुए थेफ्ट पे और कन्विक्ट हुए हो, पहले भी आप कन्विक्ट हुए थे, तो फिर प्रीवियस कन्विक्शन विल बी रेलिवेंट, एंड आई टोल्ड यू दैट प्रीवियस कन्विक्शन कैन बी रेलिवेंट टू एनहेंस द सेंटेंस, टू एनहेंस द क्वांटम ऑफ सेंटेंस. So A is charged with theft and with having been previously convicted of theft. The previous conviction is relevant as a fact in issue. Is relevant as a fact in issue in order to increase the quantum of sentence. And quantum of sentence always be a part of fact in issue. Now next illustration. A is tried for the murder of B. The fact that B prosecuted A for libel, मतलब पहले B ने A को लाइबल के लिए, डिफेमेशन के लिए प्रोसिक्यूट किया था, and that A was convicted and sentenced is relevant under section 8. Why? As showing the motive for the fact in issue. Earlier, B has filed a suit against A for defamation. B has filed a suit against A for defamation earlier, and he has got A convicted. तो क्रिमिनल मैटर होगा सेक्शन 499 आईपीसी, जिसमें A got convicted because of the defamation proceedings which is initiated by B. Now A, in order to take the revenge, he killed B. अब is not the previous conviction of A is a relevant fact and something which gave rise to motive. अब देखो ये सेक्शन वैसे तो आसान लग रहा है, पर इसको पढ़ के काफ़ी अच्छे से रिवाइज करना, इस पर अप्लाइड क्वेश्चन पूछ सकता है। अब प्रीवियस जजमेंट कब रेलिवेंट होगा और कब नहीं होगा? रेलिवेंट तब होगा जब 40 till 42 में प्रूव हो जाए, और या फिर किसी और सेक्शन में मोटिव और व्हाटएवर प्रीवियस कन्विक्शन मोटिव एक्सेट्रा, so it is relevant in any other section, then the previous judgment be relevant, otherwise it will not be relevant. And one kind of judgment in section 41, that is judgment in rem, and if it is passed by 4 courts, then it will be considered to be a conclusive proof. Now section 44, any party to a suit or other proceeding may show that any judgment, order or decree which is relevant under section 40, 41 or 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it or was obtained by fraud or collusion. मान लो अगर जजमेंट रेलिवेंट हो भी जाए, लेकिन अगर आप प्रूव कर दो कि जजमेंट वाज ऑब्टेन्ड बाय फ्रॉड और कॉल्यूजन, देन द रेलिवेंसी ऑफ द जजमेंट विल बी लॉस्ट. फिर से पढ़ो. एनी पार्टी टू अ सूट और अदर प्रोसीडिंग may show that any judgment, order or decree which is relevant under section 40, 41, 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it or was obtained by fraud or collusion. अब जैसे कोई मैटर मान लो हस्बैंड वाइफ के डिवोर्स का, हस्बैंड वाइफ का डिवोर्स कर दिया कोर्ट ने, डिक्री इज पास्ड. Now is it relevant? Now tomorrow if there is suit between wife and some third person for property, will that previous judgment will be relevant under section 41? Answer is yes. We had seen this example. Answer is yes. But if it is proved that the court which passed the decree was a civil judge's court, जबकि marriage divorce matter will goes to the district court, so that court which passes the decree was a civil judge's court is incompetent. So will that previous judgment will be relevant in the present suit? Answer is no, because it has to be proved to be passed by incompetent court. Similarly, if you find that the husband has obtained the decree against the wife by committing some fraud upon the court, कुछ झूठे डॉक्यूमेंट, कुछ झूठे फैक्ट प्रेजेंट करके डिवोर्स ले लिया, सो विल दैट जजमेंट देयरफॉर बी रेलिवेंट एज प्रीवियस जजमेंट? आंसर इज नो. सो अगर फ्रॉड करके, कॉल्यूजन करके या बिना कॉम्पिटेंसी के किसी कोर्ट ने जजमेंट पास किया हो, देन दैट जजमेंट विल नॉट बी रेलिवेंट इन सब्सिक्वेंट सूट और प्रोसीडिंग. सो सेक्शन 44 is an enabling provision and the policy is that the judgment obtained by false suit or wrong judgment or judgment obtained by wrong court, false suit cannot become relevant in deciding the other suit or proceeding. Judgment obtained by wrong court or false suit, fraud, etc. cannot be relevant in deciding other suit or proceeding. So that's it for this section. Now we would start the topic burden of proof. But उससे पहले just let's discuss 1 or 2 3 points, general points which are independent. अब suppose किसी केस में एक पार्टी किसी विटनेस को बुलाना चाह रही है, और दूसरी पार्टी उसको रोकती है आने से। अब उस सिचुएशन में कोर्ट क्या कर सकती है? द कोर्ट में ऑलवेज समन दैट विटनेस। अब मान लो कि उस दूसरी पार्टी ने उसको रोक रखा, वो आने नहीं दे रही, तो कोर्ट प्रोसीडिंग्स का दूसरी पार्टी विरोध कर रही है। द कोर्ट कैन ऑलवेज इनिशिएट द क्रिमिनल प्रोसीडिंग्स अगेंस्ट दैट पार्टी इफ इट इज प्रूव्ड। अब विटनेस सम्मन के बाद नहीं आ रहा, वो प्रूव कर देता कि मुझे इसने नहीं आने दिया, इसने बंद कर दिया था, तो विटनेस पे तो कोई लायबिलिटी नहीं आएगी, लेकिन उस अदर पार्टी के खिलाफ इंडिपेंडेंट क्रिमिनल प्रोसीडिंग्स हो सकती हैं, उस सूट में कुछ नहीं होगा। द कोर्ट विल नॉट लिंगर एंड डिले द प्रेजेंट प्रोसीडिंग्स। उस केस की प्रोसीडिंग्स लिंगर नहीं करेगी कि इस विटनेस नहीं आ रहा था। And if that witness earlier had given on the same fact evidence on the same fact in other proceedings, other case, then the court will take the previous evidence as in section 33 and use that in the present case. So, but उस witness के खिलाफ order हो सकता है, that is basically the summon order. Next point is, what is the difference between the identification parade of suspect and chatters? Identification parade of suspects and chatters. अब देखो, आइडेंटिफिकेशन परेड ऑफ सस्पेक्ट्स मींस कि टीआईपी में आप एक सस्पेक्ट की, एक्यूज्ड की पहचान करते हो, और चैटर्स मींस फाइंडिंग ऑफ प्रॉपर्टी। अब जैसे कोई मोबाइल खो गया किसी व्यक्ति का, एक व्यक्ति पकड़ा, उस पर कई सारे मोबाइल हैं, अब जो विक्टिम्स हैं अलग अलग जिनके मोबाइल चोरी हुए थे उनको बुलाया आइडेंटिफिकेशन के लिए, तो उन्होंने अपना मोबाइल आइडेंटिफाई किया by certain marks or all that. So those persons will be asked to come and identify their mobile. So that process will also called the identification parade, but that is identification parade of object, of things. और identification of suspect में accused का identification होता है, और identification of chatter में that is the identification of the property. अब जैसे कोई और ऑब्जेक्ट होगा, मोबाइल तो मान लो IMEI नंबर से हो जाए आइडेंटिफाई, बट और कोई ऑब्जेक्ट होगा तो कई सारे ऑब्जेक्ट्स में से उसमें आइडेंटिफाई करने के लिए वो मार्क्स होगा, या फिर कोई डिजाइन होगी, ज्वेलरी है तो डिजाइन बताएंगे, उसकी स्लिप है, ऑल दीज थिंग्स यू हैव टू प्रोवाइड। एकदम सामने नहीं रखेंगे, पहले पूछेंगे आपसे आइडेंटिफिकेशन, फिर उसके बेसिस पर वो प्रोड्यूस करेंगे जब आप आइडेंटिफाई करोगे, तो एकदम तो विश्वास नहीं करेंगे। नाउ द अदर पॉइंट इज, incoherent dying declaration is, even though they are admissible, even though they may be admissible, but they are not reliable. अब सपोज कोई व्यक्ति कहता है एक डाइंग डिक्लेरेशन में कि पहले तो बोलता है कि मैं छत पे था और केले के छिलके पर पैर पड़ा और स्लिप होकर मैं गिर गया, और दूसरी तरफ वो कहता है उसी डाइंग डिक्लेरेशन में कि मेरे को पीछे से इसने धक्का दे दिया। So are they not incoherent with each other, these statements? Because on one end you are saying that it is accidental, and the other statement you are saying he has pushed me, in the same dying declaration. So in this dying declaration there are internal contradictions, and that is what is called the incoherent dying declaration. So such kind of dying declaration, even they would be admissible, they may be admissible, but they are not reliable. Now next point, can dying declaration be treated as an FIR? Answer is yes. Suppose victim gives a dying declaration and he dies, lodges the dying declaration and he dies, the same dying declaration can be used as FIR. Now next point, suppose a question arose regarding the fit medical state of a victim for giving a dying declaration. Upon the fit medical state of the victim for giving dying declaration, the question arose. Here in this there is a fitness certificate of the doctor, but the defense is able to contradict the same by the testimony of the eyewitnesses. डॉक्टर ने तो फिटनेस सर्टिफिकेट दे दिया है, but there are some eyewitnesses in the hospital, maybe some staff and all, and who declares that the witness is not at all in the fit state of giving the dying declaration. Then in this situation, what will be the court do about the reliability and admissibility of the dying declaration? अब इस सिचुएशन में भी वही लॉजिक लगेगा जो पोस्टमार्टम और इंक्वेस्ट रिपोर्ट में पढ़ा था हमने। अब जैसे यहाँ पे फिटनेस सर्टिफिकेट इज गिवन बाय द डॉक्टर, दैट विटनेस इज Victim. Victim is in fit state of orientation and disposition, but the eyewitnesses were present on the spot. They find that the victim is not at all in fit state. Victim was not able to speak. So in that case, the court will simply examine the doctor also and will examine the eyewitnesses also. And whoever is more convincing to the court, able to convince the court, whoever is more able to convince the court, whoever is able to convince the court will go by that witness for that particular evidence. अब मान लो आई विटनेस एक से ज्यादा है और सबका कहना है कि वो बोल ही नहीं पा रहा था और इन्होंने अपनी मर्जी से लिख लिया, तो ये अगर प्रूफ हो जाए, then despite the fitness certificate, the dying declaration will be rejected. Then in that case the court will be more tilted towards the eyewitnesses. So that is all depend upon the examination done by the court, because everything is not written in the books or acts. So various powers are given to the as a discretionary power to the courts only, because in each and every case there are new circumstances and problems will arise. Now let's start with the topic. Chapter 7, the burden of proof, from section 101 onwards. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts, must prove that those facts exist. Dependent on the existence of facts which he asserts, must prove that those facts exist. Now you see what happened is, अब बहुत ध्यान से सुनना, क्योंकि ये जो 101, 102 और 103 का डिफरेंस है, that is very important. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts, must prove that those facts exist. So 101 is called permanent burden of proof, or it is also called primary burden of proof. It is also called permanent or primary burden of proof, original burden of proof. अब what they are saying is, मान लो A ने सूट किया B के ऊपर, he has got a cause of action, and you know that what is cause of action. For example, there is a contract and B has done the breach of contract. There is a contract between A and B has done the breach of contract. So that is a cause of action or not? So that is the cause of action. So he has gone to the court with two facts, that one is there is contract and second is breach of contract, and I want damages. Now two facts means what? Two elements of the cause of action. One is existence of the contract and two is breach of the contract. Now what they are declaring in 101 is that it is the burden of that party who goes to the court to prove those facts on the basis of which he has taken the proceedings. Means the ultimate burden, after all the trial and everything, the ultimate burden of proving that there was a contract and contract was breached, means the ultimate burden of proving the cause of action is lie upon the party who has gone to the court. That is the plaintiff. And section 101 is just making a declaration. अब जैसे मान लो डिफेमेशन का केस ले लेते हैं. If a person defamed other, अब जिसका डिफेमेशन किया है उसने सूट किया उन पर, that this person has defamed me. So if he has filed a suit of what? That there was a publication by this person and the publication is aimed at him and the publication is defamatory. So these are three facts. So that is the cause of action. Now after the trial and everything in the suit, ultimately the burden will lie upon him. To prove these three elements. that there was a publication and publication was aimed at him and publication was defamatory. So ultimate burden in proving the case in his favor lies upon the plaintiff. Similarly, in the criminal matter, suppose the prosecution prosecutes A for murder. तो prove करना पड़ेगा that A killed, number 2 the A had the intention to kill, etc. तो अब ये जो facts हैं, fact in issue, इनको prove करने का ultimate burden किस पर होगा? Prosecution पर. So when the trial will take place, the opposite party defense will also raise his evidences. Everything will be done, but ultimately the burden of proving in the case would lie upon the prosecution. तो मतलब मैं भी अपने एविडेंसेस दूंगा, आप भी अपने एविडेंसेस दो, लेकिन अल्टीमेटली क्योंकि केस लेकर मैं आया हूं तो बर्डन मेरे ऊपर होगा कि मैं केस अपने फेवर में प्रूव कर सकूं. दैट इज व्हाट इज कॉल्ड द प्राइमरी और परमानेंट बर्डन ऑफ प्रूफ, ओरिजिनल बर्डन ऑफ प्रूफ. यू सी, whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. Now the whoever desire any court to give judgment, the plaintiff will desire court to give judgment in his favor, and prosecution desires, in criminal cases, prosecution desires court to give judgment in its favor, in the favor of the prosecution. So whoever desires any court to give judgment as to any legal right or liability dependent on existence of facts which he asserts must prove that those facts exist. मतलब अल्टीमेट बर्डन आपके ऊपर होगा कि आप प्रूव करो कि वो फैक्ट एग्जिस्ट करते हैं. अब when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. Now illustration देखिए. A desires a court to give judgment that B shall be punished for a crime which A says B has committed. So A must prove that B has committed the crime. तो ये बहुत जनरल सा डिक्लेरेशन है कि जब आप कोर्ट गए हो और आप ये कह रहे हो कि उसने ये किया है, तो अल्टीमेट बर्डन आपके ऊपर होगा कि आप प्रूव करो उसने जो एलिगेशन आप लगा रहे हो वो किया है. नेचुरल जस्टिस रिक्वायर्स that he should also be given the opportunity. Natural justice requires that he should also given the opportunity to prove his evidences, and you give your evidences to prove that fact. And at the end of all, ultimately the final burden lies upon whom? The party who has gone to the court. अब दूसरा देखो. A desires a court to give judgment that he is entitled to certain land in the possession of B. A desire a court to give judgment that he is entitled to certain land in the possession of B by reason of facts which he asserts and which B denies to be true. A must prove the existence of those facts. What facts? That he is entitled to a particular land. 101 lays down a general declaration of the primary or permanent burden of proof. Who had the burden of proof? अब देखो, अब मान लो यहाँ पर सूट फाइल हुआ. अब इस सूट में ट्रायल में बहुत कुछ होगा. ट्रायल स्टार्ट हो गई, बहुत कुछ होगा. प्लेंटिफ भी बहुत कुछ प्रूव करेगा, डिफेंडेंट भी बहुत कुछ प्रूव करेगा. अल्टीमेटली आगे जाके दोनों पार्टीज के बीच में आर्गुमेंट्स होंगे. प्लेंटिफ ने अपने एविडेंसेस प्रूव कर लिए, डिफेंडेंट ने अपने एविडेंसेस प्रूव कर लिए. फाइनली आर्गुमेंट्स होंगे और उसके बाद जजमेंट प्रोनाउंस होगा. अब इस स्टेज पर द कोर्ट विल लुक अपॉन whom? At that stage the court will look upon A, the plaintiff, in A versus B. At this stage the court will look upon A as to whether you are able to prove your facts or not. Now suppose B has to able to prove some evidences which is better, so obviously A is not able to prove his fact, so the suit is dismissed. But if A has been able to prove the better evidences, so ultimately the main fact, the fact related to the cause of action, he is able to prove, then he will be given the decree in his favor. तो वहाँ पर then he is able to fulfill the burden of proof in his favor. So that is what is called the primary or permanent burden of proof. जबकि 103 is talking about burden of proof about a particular fact. जबकि यहाँ पर जो burden of proof है, that is the burden of proof regarding the entire suit or of entire proceeding, and section 103 talks about the burden of proof related to a particular individual fact. अब इस पे लिख लीजिए एक सेंटेंस. Section 101 relates to the burden of proof relating to entire suit or proceeding, and not related to any one individual fact, not related to any one individual fact. Section 103 relates to the burden of proof regarding the individual facts. Now see section 103. Read 103. The burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the proof of the fact shall lie on any particular person. So in the latter part they are talking about the presumptions. अब presumptions पे बाद में आएंगे, पहले आप मेन पॉइंट है जो उसको समझो. अगर आप कंपेयर करो 101 और 103, if you read 101 again, so 101 is saying whoever desires any court to give judgment. So judgment is based upon several facts, no? Whoever desires the court to give any judgment, so that will be based upon several facts. The cause of action. So if you prove the cause of action, or if you prove the fact in issue, the judgment will be in your favor. If you want the court to give the judgment in your favor, the burden of proof to prove the fact in issue, to prove the cause of action, that is upon you. So here they are not talking about any particular fact. You see, when A files a suit, he files a suit on cause of action. It means there are several facts in issue. Now A will have several facts to prove. Then after that B will have several facts to prove. So these are the individual facts which B will prove, and these are the individual facts which A will prove. These are the individual facts which A will prove, and these are the individual facts which B will prove. लेकिन अल्टीमेटली पूरे केस का जजमेंट अपने फेवर में प्रूव करने का काम किसका होगा? ए का. So that is what is talked about in 101. लेकिन 103 is talking about the proving of that individual facts. For example, say suppose B wants to prove alibi in a criminal case, that I was present elsewhere. So B wants to prove alibi. So that is an individual fact. And as of individual fact, who is having the burden of proof to prove that individual fact? B, because he wants the court to believe that there was an alibi and he was present elsewhere. Now suppose criminal matter है और the prosecution wants to prove a fact of fingerprint, that the pistol has the fingerprint of the accused. Now who wants to believe the court that the fingerprints on the pistol was of the accused? The prosecution, and therefore the burden will lie upon the prosecution. अब देखो सूट या प्रोसीडिंग कोई चलती है तो एक तो होता है समेशन ऑफ ऑल द फैक्ट्स एंड अल्टीमेटली द जजमेंट गोइंग इन फेवर ऑफ द प्रोसिक्यूटर और द प्लेंटिफ. उसके लिए द बर्डन ऑफ प्रूफ जनरली दे आर डिक्लेयरिंग इन 101. बट उस एक जजमेंट में, उस एक ट्रायल में बहुत सारे फैक्ट्स होंगे जो एक पार्टी प्रूव करेगा, बहुत सारे फैक्ट्स होंगे जो अपोजिट पार्टी प्रूव करेगा. तो वो जो इंडिविजुअल फैक्ट्स का जो बर्डन ऑफ प्रूफ होगा that will lie upon that person who wants the court to believe on that particular individual fact. Who wants the court to believe upon that particular individual fact. So that is where the difference between 101 and 103 lies. अब जैसे केस को अपने फेवर में प्रूव करने का बर्डन किस पर है? प्रोसिक्यूशन पर, क्रिमिनल केस में। द बर्डन ऑफ प्रूविंग द केस इन वंस फेवर lies upon the prosecution, proving that the A has intention to cause death, and then A actually has caused the death of B, etc. So that burden will be upon the prosecution. But in order to prove that, the prosecution will have several facts. For example, conduct, motive, discovery statement, if there is dying declaration, if in a case there is confession. These all facts will be proved by whom? The party who wants the court to believe that fact. And here the prosecution wants the court to believe that fact. The defense wants to prove private defense. हालांकि उसके लिए सेक्शन 105 अलग से है, लेकिन प्रूविंग द प्राइवेट डिफेंस, इन फैक्ट्स को प्रूव करने का बर्डन किसके ऊपर होगा? डिफेंस के ऊपर। प्रूविंग द फैक्ट ऑफ एलिबाई, इस फैक्ट को प्रूव करने का बर्डन किस पर होगा? डिफेंस पे होगा। तो ये जो बर्डन है इंडिविजुअल फैक्ट्स का, दैट इज डिक्लेयर्ड इन सेक्शन 103. अब एट टाइम्स व्हाट हैपन इज देयर इज अ पर्टिकुलर प्रिजम्पशन. आईपीसी में आप लोगों ने पढ़ा होगा इन द केस ऑफ डाउरी डेथ, अंडर सेक्शन 113B देयर इज अ प्रिजम्पशन, एविडेंस एक्ट. एविडेंस एक्ट में एक और आपने सेक्शन 112 पढ़ा है, कंक्लूसिव प्रूफ का प्रिजम्पशन. तो अब ये जो फैक्ट है, तो हो सकता है देयर इज बर्डन ऑफ प्रूफ अपॉन पार्टी ए, बट बिकॉज ऑफ द प्रिजम्पशन द बर्डन विल शिफ्ट अपॉन पार्टी बी. Because of presumptions, the burden will shift upon party B. If there is a burden of proof upon party A, there are certain sections which are starting from 106 onwards. You will find that there are certain presumptions of the fact, and because of those presumptions, the burden of proof will shift upon the opposite party. So that is what they are declaring in here in 103. They are saying the burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. Means unless there is a presumption which shifts the burden of proof upon the opposite party. Illustration देखिए. A prosecutes B for theft and wishes the court to believe that B admitted the theft to C. अब ये एडमिशन प्रूफ करना चाहता है सेक्शन 21 में. अब इसका बर्डन किस पर होगा? A पर होगा. So A must prove the admission. अब B wishes the court to believe that at the time in question he was elsewhere, means alibi. So he must prove it. So the burden of proof of the individual fact lies upon the party concerned, unless because of the presumption the burden was shifted upon the opposite party. And the burden of proving of the entire case in your favor lies upon that party who moved to the court. So write upon it. Unlike section 101, section 103 deals with the burden of proof of individual facts. The burden of proving the entire case would lie upon the party who has moved the court, bracket में लिख लो section 101, who has moved the court, but the burden of proving on individual fact related to the case would lie upon the party who alleges the particular fact. For instance, if the prosecution alleges that the accused has absconded seeing the police, the burden will lie upon the prosecution. The accused has absconded seeing the police, मतलब पुलिस को देखकर भाग गया. The burden will be lie upon the prosecution. आगे लिखो. Similarly, if the prosecution wants to prove the dying declaration, if the prosecution wants to prove the dying declaration, similarly, if the prosecution wants to prove the dying declaration, the burden will lie upon the prosecution. The burden will lie upon the prosecution. And if the defense wants to prove alibi, the burden would lie upon the defense. ठीक, तो मतलब क्या हुआ कि एक पूरा केस है और मैं कोर्ट में गया हूँ केस लेकर, तो बर्डन मेरे ऊपर है कि केस मैं अपने फेवर में प्रूव करूँ, लेकिन मैं उसको कैसे प्रूव करूँगा? उसके लिए मुझे बहुत सारे इंडिविजुअल फैक्ट्स प्रूव करने पड़ेंगे। तो मैं अपने फैक्ट्स प्रूव करूँगा, इंडिविजुअल फैक्ट्स, उससे अपना केस प्रूव करूँगा। अब अपोजिट पार्टी डिफेंस कैसे लेगा? उसके पास भी बहुत सारे इंडिविजुअल फैक्ट्स होंगे, उनको प्रूव करके वो अपना डिफेंस लेगा। अब उन सब को देखने के बाद अल्टीमेटली प्लेंटिफ या प्रोसिक्यूशन की ये कोशिश होगी कि वो केस अपने फेवर में प्रूव करे। अगर मेरे फैक्ट्स ज़्यादा हैं, ज़्यादा रिलायबल हैं और आपके फैक्ट्स नहीं हैं, तो केस मेरे फेवर में हो गया। मीन्स व्हाट? आई विल प्रूव द बर्डन ऑफ प्रूफ इन अंडर 101, and while I was proving those individual facts, I was fulfilling my burden of proof under 103. Now see section 102. 102 is talking about shifting of burden of proof, जिसको कहते हैं onus probandi. Onus probandi, that is also called secondary burden of proof or shifting burden of proof. Secondary burden of proof or shifting burden of proof, it is also called onus probandi. probandi. Onus probandi. अब इसका क्या मतलब हुआ? What is meant by shifting burden of proof? Without looking the bare act, what do you understand by shifting burden of proof? It means if a person fulfill its burden of proof, now the burden shifts upon the opposite party to prove some other fact. What happens? That is very simple, I tell you. Suppose there is a criminal trial. If the trial starts, अब who will give the evidence first? पहला evidence तो prosecution देगा. Now suppose prosecution today give the evidence number 1. अब यहाँ पर सोचो, इसके बाद ट्रायल में कुछ ना हो. No more evidence given by the prosecution. No more evidence is produced by the prosecution nor by the defense. Now who will win the case? Now suppose prosecution ने जो पहला एविडेंस प्रोड्यूस किया, that is upon motive. अब दूधनाथ पांडे केस का जो था उसका एग्जाम्पल याद करो, उसको केस को लेते हैं। अब मोटिव का एविडेंस प्रोड्यूस किया तो उतने में प्रोसिक्यूशन डज नॉट विन द केस। अब प्रोसिक्यूशन अगर और कोई एविडेंस नहीं देगा, देन द डिफेंस विल विन द केस because you are not been able to prove your case, and therefore the burden of proof will not shift upon the opposite party, it will still remain upon the prosecution. क्योंकि रूल ये है कि अगर इस स्टेज पे ट्रायल रोक दिया जाए, रूल ये है कि अगर इस स्टेज पे ट्रायल रोक दिया जाए और कोई एविडेंस ना दिया जाए, then which party stands to lose the case? Which party stands chance to lose the case? So whichever party at that stage stand to lose, the burden will be upon him to prove his case. So here you prove only the motive in the Dudnath Pandey, that he is having the motive to marry that girl, etc., etc. And only motive cannot convict the accused, and therefore, if nothing more is done, then who stands to lose? Who stands to lose? Prosecution will lose, and therefore the burden will still lie upon the prosecution. Now again prosecution produce some main evidence. Suppose they produce the discovery statement. Suppose they prove the discovery statement. Now again you see the same thing, that motive has proved and the discovery statement has proved. Then are they two are sufficient to prove the case, or something more is required? If something more is required, then means what? The prosecution has chance to lose the case, and therefore the burden of proof still lies upon the prosecution. Then after that, prosecution produce third evidence, that is eyewitnesses. Now here who is going to lose the case? अब यहाँ पर थोड़ा सा prosecution is in the direction to winning the case, because eyewitness भी है, discovery statement भी है, motive भी है, so slightly they are moving in the direction of the winning of the case. And next they will be proving, suppose the things set in the same transaction, the sisters FIR etc. Now here who stands to win the case? हालांकि यहाँ पे और भी एविडेंसेस हैं, पार्टी अपने सारे एविडेंसेस प्रूव करती है, लेकिन यहाँ पर देखोगे आप कि आई विटनेस भी है, डिस्कवरी स्टेटमेंट भी है, सेम ट्रांजैक्शन वाला फैक्ट भी है और उधर मोटिव भी है, तो दिस मच इज सफिशिएंट टू कन्विक्ट द एक्यूज्ड. तो देयरफॉर अगर अब इसके बाद अगर कोई भी एविडेंस नहीं दिया गया, देन हु विल विन द केस? Prosecution will win the case, and who will lose? Defense will lose. And therefore at this stage, if the prosecution does not have any more evidences, and therefore at this stage the burden of proof will shift, and now it shifts upon the defense. तो ये जो सिस्टम है, ठीक उस स्टेज पर जो उस केस को लूज करने का चांस है, उस स्टेज पर लूज करने का चांस है जिसका, उसी के ऊपर बर्डन ऑफ प्रूफ होगा, एंड बर्डन ऑफ प्रूफ विल शिफ्ट अपॉन दैट पर्सन. दैट इज व्हाट इज कॉल्ड शिफ्टिंग बर्डन ऑफ प्रूफ. So that is what they are saying here. If you read the section, the burden of proof in a suit or proceeding, lies on that person. देखो एक तो होता है कि क्या प्रूफ करोगे, तो उधर तो यू नो दैट ये केस प्रूव करूंगा मैं या ये फैक्ट प्रूव करूंगा, उसका बर्डन ऑफ प्रूफ मेरे ऊपर है, लेकिन कब प्रूफ करोगे? व्हाट विल यू प्रूव? दैट इज इन 101 एंड 103. बट व्हेन विल यू गिव योर एविडेंस? दैट इज देयर इन 102. द बर्डन ऑफ प्रूफ इन ए सूट और प्रोसीडिंग लाइज ऑन दैट पर्सन हु वुड fail if no evidence at all were given on either side. Means what? Means at that stage, if no evidence were given on either side, then who will fail? Whoever will fail, he has the burden of proof. Now at this stage, after the same transaction evidence has been given, who will fail? It may be more of defense, and therefore the burden will now shift upon the defense. Suppose in this case defense want to prove the alibi. Now in this case मान लो they are able to prove the alibi. Suppose now in that case, after the proof of the alibi, who stands to lose the case? Whose chance are to lose the case? Prosecution will lose the case, and therefore now the burden will shift upon the prosecution. Now if the prosecution says that I will not having the more evidences, अब जैसे याद करो आप वो वाला केस, यूनियन टेरिटरी ऑफ दादरा एंड नागर हवेली वर्सेस फतेह सिंह चौहान, वो डिस्ट्रिक्ट कलेक्टर वाला केस याद करो, उधर आपने अपने सारे फैक्ट प्रूव कर दिए, द प्रोसिक्यूशन विल सक्सीड एंड देयरफॉर द बर्डन विल गोज अपॉन द डिफेंस. देन द डिफेंस प्रूव द एविडेंस ऑफ दोज टू ऑफिसेज ऑफ द डिस्ट्रिक्ट कलेक्टर ऑफिस, इफ यू रिमेंबर. And now thereafter the alibi has been proved, and therefore the defense will succeed. So now who wins and who will lose? The prosecution will lose, and defense chance are to win. So now the burden of proof will shift upon the prosecution. Now if the prosecution finds some evidence, that is fine, but if it is unable to find evidence, then it will decide against the prosecution. So there in the end, when the burden of proof shifted upon the prosecution, after the defense proved the alibi, there the prosecution comes with an application, if you remember, and the prosecution says that I want to summon the collector. Means इस stage पर burden of proof prosecution का है, अगर prosecution prove नहीं कर पाता तो फिर केस डिफेंस के फेवर में चला जाएगा. And since in this case they are having the evidence of the collector, so they have applied for summoning of the collector. Because burden of proof initially was upon the prosecution, then prosecution proved sufficient matter, and then the burden of proof shift upon the defense. Then after the defense proved the sufficient matter, the burden again shift upon the prosecution. If they have any evidence, fine. Otherwise the case would decide against the prosecution. So this is what is called the shifting of the burden of proof. कभी एक पार्टी के ऊपर होगा, कभी दूसरी पार्टी के ऊपर होगा. तो जिस पार्टी के हारने के चांसेस हैं, बर्डन ऑफ प्रूफ उस पर शिफ्ट हो जाएगा. जिसके हारने के चांसेस हैं उस पर होगा बर्डन ऑफ प्रूफ. अब वो हर मूवमेंट पर चेंज नहीं होता. बहुत सारे एविडेंसेस प्रूफ कर लो, उसके बाद बर्डन ऑफ प्रूफ दूसरी पार्टी पे होगा. वो भी अपने बहुत सारे एविडेंसेस प्रूफ कर ले, तब बर्डन पहली वाली पार्टी पे होगा. सो this burden of proof shifts not after every fact, it will shift after some facts. So जब तक prosecution अपना केस प्रूफ ना कर दे, तब तक burden defense के ऊपर नहीं जाएगा. Once the prosecution proves the case so as to convict the accused, now the defense gets the burden of proof. Now if the defense had the evidence is then fine, otherwise the prosecution will win. That is of the shifting of the burden of proof. Of the difference between 101 and 101, 103 and 102 is that what will you prove for the entire case, that is 101, and in 103 what will you prove, the particular fact you are alleging, and when will you prove, that depends whether you have burden of proof at that stage or not. See, the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Now see illustrations. A sues B for land. A sues B for land of which B is in possession. Possession में कौन है? B. A sues B for land of which B is in possession and which, as A asserts, was left to A by will of C, B's father. If no evidence were given on either side, B would be entitled to retain his possession. क्योंकि B ऑलरेडी पोजेशन में. अब A कह रहा है कि मुझे वसीयत के थ्रू लैंड मिला है, तो फिर अगर A कोई भी एविडेंस नहीं देगा तो फिर प्रॉपर्टी किसके पास चली जाएगी? B के पास. Therefore, who will lose? A will lose, and therefore the burden will lie upon A. Therefore, the burden of proof is on A. Now, next illustration is A sues B for money due on a bond. A sues B for money due on a bond. The execution of the bond is admitted, but B says that it was obtained by fraud, which A denies. If no evidence were given on either side, A would succeed as bond is not disputed and the fraud is not proved. Therefore, the burden of proof is on B. मतलब जो भी पार्टी है, whoever goes to the court, अगर उसने evidence नहीं दिए तो he will lose. Therefore, the initial burden lies upon him. And if he proves the sufficient matter, the burden will shift upon the opposite party. If that party proves the sufficient matter, then the burden will shift again upon him. If he will have the sufficient evidence, then he will succeed, otherwise the opposite party will succeed. So this is what is called shifting of burden of proof या onus of proof. onus of proof जो है उस स्पॉट पर उस समय कौन प्रूव करेगा, that is onus of proof. 101 and 103 relates to burden of proof and 102 relates to onus of proof. 101 and 103 relates to burden of proof and 102 relates to onus of proof. तभी तो कहते हैं onus probendi. onus और burden मीनिंग तो दोनों का सेम ही है, but conventionally we are using the word onus in reference to 102. burden और onus में there is no difference, but conventionally we are using the word onus with reference to 102. So that's it for this section and this class also. Thank you.